Ms. O'Brien? Good morning.
Good morning, Your Honors. Leslie O'Brien for Philippe Mercado. May it please the Court.
Susan.
As the Court knows, Mr. Mercado was convicted in 2004 of murdering his wife, Mandy Mercado. His principal defense was lack of criminal responsibility, and he also argued in the alternative that his discovery of his wife's recent infidelity mitigated the crime to manslaughter. In regard to the first issue raised in Mr. Mercado's brief, there was a tremendous amount of what I've termed prior bad act evidence or uncharged misconduct evidence that led to a substantial likelihood of a miscarriage of justice in this case. And I'd ask the Court to consider in that regard the closeness of the issue in this case. And I'm recognizing that a defense of lack of criminal responsibility is certainly difficult to support, and I know that that's well recognized and appreciated. But this was a case really where the issue was close to the point where the prosecution's own expert referred to the case as, in some ways, a difficult case, even though he eventually reached the conclusion that Mr. Mercado was responsible. He recognized that there were difficulties and that this wasn't as clear-cut as some cases may be in that regard.
Ms. O'Brien, the Commonwealth argues that part of the strategy of defense counsel was showing this prior history of mental illness, yes, but mental illness combined with acts of violence that were connected to it, and so it, in other words, it boils down to it was part of the tactical approach, and so that the evidence that you thought should be redacted from these records was really a part of what needed to be presented for that purpose.
Yes, I understand that that's the argument, Your Honor.
And what do you say about that?
But there was so much here that could not even arguably fall within the category of supporting the mental health defense. And some examples I'll offer are the evidence that Mercado was yelling expletives at the family, at the victim's family, at his arraignment. His admissions to selling drugs. There were several references to his being a seller of drugs. There was testimony, or not testimony, I believe, in the record of Dr. Shushman, or the report of Dr. Shushman, that was admitted without objection. There were references to the fact that there was this restraining order on a previous girlfriend, and it was said in Dr. Shushman's report that there were repeated violations of this restraining order. So those are some examples of some things that I'd suggest can't even remotely be argued to be relevant to a strategy to support the mental health defense. And in regard to that...
So you're saying that the affidavit of counsel, which is at 183 of your brief, of your appendix,
Yes.
went specifically to the experts, not to all this other stuff.
I'm not sure I understand.
This material that you're talking about now largely comes in through the report of Dr. Shushman, correct?
And I think
Well,
also
at least
his
the
own
violation
expert.
of the
Well, his own expert, the report has very little in there, really, of this type. I've looked at Dr. Shushman's report, and everything
Yes.
you've mentioned is in there, and a lot more.
I know that this is in there, although it may pop up at other points in the trial. I'm not sure that that's the only place where that's seen in the trial, but it's definitely in Dr. Shushman's report, this matter of the violation of the restraining order. And in that regard, it's...
Going back again to trial counsel, are you suggesting that he should have, that it was permissible for him not to object to some of the information contained in the reports, but to object to other pieces of the information? Or that he should just not have, wanted to get in information that he thought was helpful?
Well, I'd suggest that as to Dr. Schuschmann's report,
Right.
there was nothing there that was helpful to the defendant that didn't come in through other means in the case. There was nothing there.
So what difference does that make? Are you challenging?
I'm challenging the idea that this was a strategic decision to not object to Dr. Schuschmann's report coming in. Dr. Schuschmann's report was hearsay, not admissible under any exception to the hearsay rule, and defense counsel chose not to object to it, and it's been.
So what you're saying is it isn't a question of picking and choosing. He just should have objected to the whole thing on hearsay grounds because Dr. Schuschmann testified, and that should have been it, right?
Yes, certainly with Schuschmann's report. And to the extent that there was in the other medical record, to the extent that there were and agreed there were things in that other report. I'm blanking on the names of the medical facilities, but in the actual medical records that were admitted, certainly there were things that were helpful to the defendant there. There were his many diagnoses.
I'm sorry to interrupt you, but I really have to understand what your claim is here, because, a lot turns on whether or not we agree that this was a reasonable strategic decision by trial counsel. What he says is, I didn't object to Schuschmann's report coming in, and now you've just told me that there are lots of other ways that evidence came in, but the reason why I didn't object to it was because I wanted to get in my defendant's expert. I wanted to report a defendant's expert in. That's what he says. Because that report, Dr. Spears' report, contained information that was helpful to the defendant, and I believe would benefit the defense for that report to be available to the jurors.
But of course, without something more specific from defense counsel, in looking at the report, it's very difficult to see that there was anything in Dr. Spears' report that was helpful to the defendant that was not brought out in Dr. Spears' own testimony.
But what he's saying is, but I want the jurors to have it with them so they can look at, that's what I took his affidavit to mean. It's a very short affidavit, and maybe I'm misleading it, but that he was saying, they hear stuff. How long was this trial?
How long was what, Your Honor?
This trial. How many days?
The trial was 5 days total.
So the defense counsel thinks, look, I just want them to have it with them so they can point to it and look at it and so on and so forth. And given that all the stuff that's in Schuschmann's report is going to come in anyway.
Well, it wasn't, though.
But I'd suggest, Your Honor, that it wasn't coming in, and it wasn't coming in anyway. There wasn't any ground for these things to come in. There wasn't any theory of admissibility for all of the damaging information that was in Dr. Schuschmann's report.
If defense counsel had objected to Schuschmann's report coming in, would he have been able to get in Spears' report?
He already had, Your Honor, and I know it's been.
Schuschmann appeared as the rebuttal witness, so Spears' report
yeah.
had already been in, literally without objection, in the defense case.
Yes.
But you can anticipate that there would have been an argument that
Right.
what's good for the goose is good for the gander.
Well, that's true enough, but I come back to the point, Your Honor, that Dr. Spears had testified to everything that was helpful that was in his report, and if there was anything more that defense counsel wanted to bring out through Dr. Spears, he could have done that. I'm relying in great part on this court's decision in Commonwealth v. Dwyer, which is a 2006 case, and in that case, defense counsel failed to have redacted a medical record in which there was information that was both helpful and harmful to the defendant. And what the court said there was that it wasn't justifiable as a strategic decision because defense counsel had a couple of options.
But that was such a different case. What was in that medical report was information about the defendant's liability for the abuse of the child. Right? That's what was in that medical report. It went to the heart of the case, the liability. This stuff that you're objecting to in these medical reports go to other things that the defendant may have done, which, by the way, were consistent with the defense of this explosive behavior, intermittent explosive syndrome or something. Isn't that very different?
Well, my understanding of what I took from Dwyer that I felt was important that applied to this case was that failing to have the medical records redacted couldn't be justified as a strategic decision because there was the option of redaction and because there was the option of bringing out the helpful information through the defendant's own expert. So that's what I took from that I felt was highly relevant to the circumstances here.
If I hear you correctly, you may be saying maybe two alternatives. One is perhaps it was manifestly unreasonable as a tactical decision to want to introduce either of these reports because I think it would be fair to assume that if one pushed to introduce Dr. Spears, it's going to be hard to keep out Dr. Schuschman's if the Commonwealth wants it. So that might be manifestly unreasonable to allow it all. But even if that wasn't, it was manifestly unreasonable not to redact.
Yes.
So it's both of those.
It's both of those things that I'm arguing. That defense counsel had reasonable alternatives that didn't involve placing before the jury really highly prejudicial evidence. There was, in addition to what I've already mentioned, there were quotes from, or alleged quotes from the defendant that were brought in where he's quoted as saying that he loved punching another patient in the face. He's quoted as saying that he loved to see blood. None of that was tied in as being relevant in any way as to the question of whether he had the ability to control himself or that he did or did not suffer from this intermittent explosive disorder. There was information there that he had fought with his principal when he was in high school, that he had broken his brother's nose, that he had been engaged in 5 fights where the other person actually required medical treatment. None of this was tied in by expert testimony or otherwise to the question of whether Mercado was responsible under the McCool standard. It was just out there as for no other purpose that I can see, certainly, than painting him as a horrible individual. I did want to point out, in regard to one of the aspects of this that I thought was just particularly irrelevant and prejudicial was the material from Dr. Schuschman's report regarding the previous girlfriend and the repeated violations of a restraining order. As the court knows, there actually was a motion in limine that defense counsel brought to exclude prior bad acts, and there was some, it's unclear from the record, I'd suggest exactly what that relates to, but the prosecution has suggested on page 14 of its brief in the footnote there that what it related to was exactly this material, the violation of the restraining order, and that was allowed. And if that's correct, if the prosecution is correct that the defense was successful in having that excluded, well, he then turned around and failed to object to it being admitted in Dr. Schuschman's report. So the idea that these were some carefully weighed strategic decisions, I'd suggest really goes out the window. And I'm also suggesting that if there's a role at all for defense counsel in the courtroom, one of the most important roles has to be to protect a defendant from material that will prejudice the jury against the defendant that has no relation to any of the issues in the case, any of the legitimate issues. If I may have just a moment.
Sure.
Just very briefly, in relation to the trial judge's conclusion that the defense counsel had no other way of presenting this defense, certainly issue can be taken with that because of the diagnoses, the previous history of mental illness that was available in this case, in addition to Mercado's low intellectual capacity. His expert said he tested with an IQ of 73. In addition to that, he was diagnosed in 1999, just 2 years before the homicide, as being psychotic, with suffering from delusions and oral hallucinations, and complaining of extreme difficulty controlling anger. There were.
But the diagnosis here, I mean, the diagnosis, at least his expert's diagnosis, and the basis on which he opined that he was not criminally responsible, was this intermittent explosive, what is the right terminology here?
Intermittent explosive disorder.
Disorder, which surely needs, and I guess the theory here, or the strategy, was to demonstrate how this had occurred, not just in connection with the killing of his wife, but had occurred many times. It wasn't just that he was psychotic, it was that he had this particular disorder which resulted in bouts of uncontrollable violence.
And that he had a history, yes.
Yeah, and that he had a history of these acts of violence in connection with this disorder.
Yes, and there was history that was helpful in that regard. There was, at Bridgewater, there was the evidence in the reports that at Bridgewater he was assaultive, that he had to be placed in 6-point restraints, that he was out of control, that he assaulted a patient. I'm certainly not saying...
But that wouldn't be history, though. That would be connected to this incident, wouldn't it?
I see what you're saying, that it was after the fact, but there was information. I'm suggesting that there was information to support that defense without bringing in all
the acts of violence. Without
bringing in all of these acts of violence that were never connected to the issue of whether he had control of himself. Even the repeated references to the fact that he had homicidal ideation toward 2 high school classmates, clearly prejudicial unless it's somehow connected to whether or not he lacked the capacity for self-control. So again, you have something that's really inflammatory, and it's out there before the jury. And I should say that as in my approach to this case, I read the transcript first, and then I went to the courthouse and looked at these records. And in reading the transcript, certainly I saw some things that jumped out at me as, gee, this really shouldn't have come in. For example, that he was being supervised by someone who specialized in recidivists. That wasn't right. And there were some other things that had come out about him that I thought could certainly form some grounds for an appellate issue. But when I went and sat down in the clerk's office and started looking at the records that were introduced in this case, that's when it became so clear that the case was absolutely permeated with all of this prior bad act evidence that really did not have to come in, and that was not relevant.
Is it your, after having looked at those records, is it your view that Dr. Schuchman's report is the prime problem here?
Yes, it is. I would say it is, but also the fact that the other medical records, the actual medical records, were not redacted. Yeah,
and those medical records actually were offered by counsel at trial and opposed by the Commonwealth, presumably because there was more favorable information there than unfavorable.
Yes. I think the prosecutor originally objected, and then I'm not sure if he officially withdrew his objection, but I don't think it was strongly opposed. In any case, there's information in both sets of records that was highly damaging.
The hospital records came in just as hospital records, or did they come in on some other basis? They came in through to Dr. Spears, but how did they come in? They
came in as hospital records. Okay. And as I've argued in my brief, they were admissible only for diagnosis and treatment, but of course they came in for an awful lot more. Unless there are other questions, I will rest on my brief.
Thank you, Ms.
Thank you, Your Honors.
Semmel?
Good morning. Catherine Semmel, appearing on behalf of the Commonwealth. I think at the start, I think this is really a classic case of a defendant challenging the strategic decisions of his counsel with regard to a defense which has not been disputed. I think there's no dispute. The criminal responsibility was a good defense in this case, in a case where there were few defenses available. Identity was clear, no basis for self-defense, strong evidence of premeditation provided by the defendant himself. Criminal responsibility was the clear choice here, but in this instance it happened that it was not in your typical case of last resort because the defendant had a very well-documented history of not only mental illness, but of violence attributed to that mental illness, or at least connected with it, which he was able to present to the jury, which I think is important. And if you look at the defendant's opening statement, you can see how he started out. He's starting out trying to counter the general perception that mental illness can be a convenient excuse in cases like this. He describes the defendant as a time bomb, and he says right off, this was not something the defendant invented. There's a long history of this. There's a long history of his mental illness and his violence attributed to it. And he set that up from the very beginning. It's clear that's where he was going. And this was identified by the trial judge as well in ruling on the motion for new trial, where she both identified that defense, and also validated it and said it was a sound trial strategy to try to substantiate defendant's mental illness and its association with aggressive acts as dating back many years before he stabbed his wife. So that's clear, the setup.
I understand that, and I can see why that explains the defendant's desire to get the hospital records in. I do not understand this Dr. Schuschmann's report at all, how that is admissible, how any reasonable counsel could have permitted that to come in. It talks about him stealing cars, selling drugs, on and on and on, having nothing to do with mental illness and its related violence. How did that come in?
I think we are talking about two different strategic moves here. The Atlantic Care was based on his theory of violence. In this case, I think the strategic decision between not objecting to Dr. Schuschmann's report is just what he stated to appellate counsel when he was questioned about it, that he wanted the report in from his expert. And certainly there is a trade-off.
The expert's report is not very, Spear's report, right?
Yes,
It's
exactly.
not very long. It's 5 pages or 6 pages or something. And it's not peculiarly, it doesn't have useful.
But it has what the defendant needs in it to support his defense.
Didn't Spears, I haven't read Dr. Spears' testimony, but didn't he essentially testify to all that stuff anyway?
For the most part, yes, he
So
does testify to it.
what's this huge advantage to having them have it in front of them?
I think it's just for them to review. I think it gives it a little
but
more solidity, having the report in front of them. I think that they can look at it and scrutinize it more carefully. And I think there's always a benefit to having a report.
About the report you were just asked about, what about
Schuschmann's?
Schuschmann's?
What about
What's the
Schuschmann's?
purpose of that one?
Oh, I don't think there was a purpose to having Schuschmann's report in. I think he wanted his report in. And, I think...
He'd gotten his report in without objection from the Commonwealth.
Well,
So now Dr. Schuschmann is testifying in rebuttal. This report includes an unbelievable amount of bad act stuff. I don't even know how the Commonwealth, what's the basis on which the Commonwealth even offered this report?
it was the
Just
report of
because?
the expert. The report of the expert.
But the report of the expert doesn't come in. How does it come in?
Without agreement. How can it without agreement?
Well, there was agreement in this
Well,
case.
I understand that, but
No
that's the
objection, but I'm
issue,
just
right.
trying to understand how, this is so bizarre that such a report would come into evidence.
Well,
Especially, and how do Ms. Summers, I don't know whether that was a question of Justice Cordy's, but in any event, why not redact it?
Well, I think that as soon as you start, let me back up. First of all, I think when you're dealing with a psychiatric evaluation, I think that you have a broader net than you do like in medical records. It's hard to say.
Fair point. Sure,
it's
because
hard
you're
to
often going back to what happened in your childhood.
Right, and you're looking at a lot of different aspects and a lot of different behavior and a lot of different things. So I think in that aspect, I think it's hard to say that anything in that report is irrelevant. That being said, I think that the defendants clearly felt it was a trade-off. There's even a conversation when they're talking about introducing Dr. Schuschmann's report, and the defendant asks if the Commonwealth is going to, this is at transcript 5, around page 90, I believe, where they talk about whether there's going to be any hearsay elicited, and the Commonwealth says, well, I'll strike my report if you strike yours, or I'll strike it if you strike yours. I mean, I think it's apparent that there was a trade-off here, and that had, in fact, the defendant brought a challenge to this, that he would have found his report out as well.
I missed where you started there.
No, but that's, our point is, so what?
And
So we really have to look to see, what was value added. What was value added by having the jury have a written report, where I say that the substance of Dr. Spear's report is not very complicated. Kid at home, abusive father, psychotic. He was the little weakling in the family. He saw his dad beat up people, and he began to follow his dad. I mean, isn't that in essence what Spear said?
it is, but it's the essence of the defense, and if...
No, I understand. So
and
if
if
Spear testifies to that, it's not really difficult for a jury to keep that in mind.
I think there's always a benefit to having the report back in the jury room when they're discussing it and they're looking back and they have questions about it and they want to understand better what the opinion is. I think.
Well, I
there's
suppose the
always-
question for us is whether it's an unreasonable strategic decision to make that,
I think that's exactly the question, Your Honor.
decision
Sure,
at the
that's-
time.
I think that's exactly the
The
issue
answer
before the
from
court.
your point of view is no.
And I'm sorry?
The answer is no, from your point of view.
The answer is no. It's a reasonable strategic decision. And when you talk about things that are in Dr. Schuschmann's report, I think you have to take them in the context of all the stuff that came in that the defendant introduced.
I understand your point, okay, but I take it from what you've just said that because of all this back and forth and negotiations, it was clear that if one was going to go in, both were going to go in, right?
I think the writing was on
Okay.
the wall, at least,
So
yes.
then I turn to Dr. Schuschmann's report and says, in summary, in my opinion, he had no mental disorder at the time that impaired his ability, in my opinion, the malingering command, auditory hallucinations, which he was talking about, and amnesia, is an attempt to avoid criminal responsibility. Carter's current functioning represents a combination. I mean, this is pretty damning stuff and very not helpful to have it in a report in front of the jury.
I think that's a strategic choice. Does he have more to gain from having
But didn't
his report than
Schuschmann
to lose?
testify to all those?
Of course, yes.
Of course, that would be what his
Certainly.
testimony was about, that he...
Yeah, but Ms.
was trying
Sennell
to
has
avoid
just made the
criminal
point that
responsibility.
even though Dr. Spear testified to it, it really helps the jury to have it right there.
But I'm saying
and I'm
that's a counsel's choice. That's a counsel's choice based on his experience. And criminal responsibility is a tough case to make. And I'm sure that attorneys gain anecdotal experience about what's helpful and what's not when they're addressing cases.
Did the issue of redaction ever come up? Was that discussed?
No, I don't believe it was.
The
It seemed to be-
test is, was it reasonable? It's not would somebody else have done it differently. And when you get reasonableness, you talk about that, you're really asking yourself, was counsel's performance so bad, that this defendant really lost his defense? And I don't think you can say that. At least you argue you can't say that.
I don't think you can say that, Your Honor, and I think that's why I think it's important when deciding whether or not defense counsel made a reasonable decision. I think you have to look at these references in Dr. Schuschmann's report, again, in relation to the evidence that had already come in. What was the additional harm of having these references before the jury when you have reams of papers that the defendant has introduced because they're consistent with his theory about the prior violence of this individual? None of this was inconsistent with the defendant's defense, and that factors into whether or not it was reasonable. As a factual matter, I just want to make one point. I did comment at one point that my understanding was that the prior bad acts motion that was brought prior to trial that one of the things that was raised was excluding evidence of violation of a restraining order. My understanding is that concerned the restraining order involved in this case, the restraining order that the defendant had, that the victim had against the defendant. And that information was, I believe, redacted from Dr. Schuschmann's report, as were the admissions that he made. And that's discussed by the prosecutor prior to that report being admitted. So my understanding was that it didn't relate to any other acts, but specifically to this case. And that's what I believe the defense counsel got excluded prior to trial. It's not clear on the record, but that's my understanding.
I'm sorry, I missed what you were saying a little while ago when you were talking about these two reports, Dr. Spears and Dr. Schuschman's.
Yes, Your Honor.
Was there an agreement or a dialogue about I won't object to yours if you won't object to mine? Did I miss something?
There was a dialogue right before Dr. Schuschman testified, I believe. There was a short dialogue about hearsay, about defense counsel was raising, this is in trial transcript 5. Defense counsel was raising some concerns that there was going to be hearsay elicited, and the prosecutor did make some reference, I'll strike mine if you strike yours, something along those lines.
Elicited in the testimony or elicited or in the report?
In the sidebar. I'm sorry.
Right, but was the conversation about what he was going to testify to?
It's not clear to me. It wasn't clear to me what they were referring to. I think they were talking about admitting the report at that.
This hearsay elicited suggests it's questions being put to him, but
That could be, Your Honor. It's not. I don't think it's particularly clear. But there was a reference, but I think it just to the extent that there is some concern by the court that the report of Dr. Spears was already in. I don't think that's a determinative point. I think that was going to be up for negotiation. And certainly if I don't think there would be a situation where the defendant was allowed to introduce his report and the Commonwealth wasn't allowed to introduce theirs. If the court has no further questions, I'd be happy to rely on my brief.
Thank you, Ms. Sano.
Thank you.